How does Interpol impact immigration bond hearing? If your immigration case involves an Interpol Red Notice or Diffusion, your chances of being detained in the US immigration detention are significantly higher than the ordinary immigration cases. In the United States, the immigration detention is not meant to be punitive, as confirmed by multiple Supreme Court's decisions. However, it's not actually good news, because unlike criminal cases, there are no specific time limiting how long someone can be detained. As a bright example, case Casas-Castrillon versus Department of Homeland Security, where a US green card holder remained in the US immigration detention for more than 7 years. Typically, from the US immigration detention, you may be released either by winning your immigration case or on bond. Cases involving an Interpol Red Notice or Diffusion are also eligible for bond hearings. In bond hearing, two main factors are considered. First, whether the individual poses a danger to the community. This means determining if the person is a risk to others or others' property. Second, whether the individual is a flight risk. Flight risk in immigration cases is slightly different than in cases involving extradition or criminal cases. In immigration cases, the concern is not that the individual might flee abroad. In fact, the US government would likely welcome that. The concern in immigration cases is that you might disappear within the US society and live in the United States unlawfully. As I explained in my previous videos, if your immigration case involves an Interpol Red Notice or Diffusion, the US government may and probably will argue that this would make you ineligible for asylum in the United States. And because of this, the US government will likely contend that you are a flight risk at the bond hearing. The logic stems from the Board of Immigration Appeals decision, usually called BIA, where the BIA found that individuals who are more likely to win their immigration case from deportation are also more likely to appear at their subsequent hearings, while those with limited chances to win on his immigration case are less motivated to appear before the government. In other words, the US government in bond hearings involving Interpol Red Notice or Diffusion will probably try to continue your detention based on the likelihood of the future developments in your immigration cases and probability of your behavior. Knowing this may help to prepare your case properly, to mitigate flight risk by presenting relevant evidence that demonstrates your ties to the community and lack of intention to disappear. This evidence can include, but not limited by, the proof of stable employment, enrolling to language courses, and evidence that your children enrolled in school, evidence about ongoing medical treatment, or character reference from the US community members. Anything that shows roots and responsibilities in the US can help. Additionally, evidence that you have acted responsibly before, such as, for example, notifying the government of any address changes, may further alleviate concerns about flight risk. It's crucial to know that bond hearing is entirely separate from deportation proceedings. This is mandated by federal regulations. So you must prepare and submit all your evidence specifically for the bond hearing. Even if you have already submitted similar evidence, in your asylum or other immigration case. Having this knowledge about the bond hearing involving an Interpol Red Notice or diffusion may help you to win your bond hearing and be released from the detention at liberty.